Crapo.
Thank you, Mr. Chairman. And Judge Barrett, welcome and congratulations on the high honor of your nomination. I have some prepared remarks here, which I will give, but having sat through the speeches that I've heard already and listened to the attacks that have been made, both on Republican members of the committee and on you, I think it's important to just set the record straight on a few items before I then talk about why we are here, and that is you and your qualifications to serve as a justice. So what were the attacks? I'd say the first one is that we're rushing too fast and that we are violating the rules and norms and precedents of the Senate and speeding into these proceedings. What are the facts? Well, I had my staff check while we were sitting here. This hearing is 16 days after Judge Barrett's announced nomination. More than half of all Supreme Court hearings have been held within 16 days of the announcement of the nominee. This case is no different. A couple of examples. Justice Stevens, 10 days. Justice Rehnquist, 13 days. Justice Powell, 13 days. Justice Blackmun, 15 days. Justice Berger, 13 days. These proceedings are following right along in the same kind of process that has historically been the process of the Senate. So then the argument is made that, well, this is an election year, and the Republicans said back in 2016 that in an election year they wouldn't move forward with then President Obama's nomination. What are the facts? A vacancy has arisen in a presidential election year 29 times. Every single one, and this is important to note, every single one of those 29 times, whoever was the sitting president made a nomination to replace the vacancy, to fill the vacancy. Every one of those 29 times. 19 of those 29 times, the parties of the president and the Senate majority were the same. And 17 of those 19 nominees were confirmed. By contrast, of the 10 times in which the Senate was controlled by the party opposite to the president, only one time did the Senate that was not of the party of the president proceed to fill that vacancy. In fact, vacancies under a divided government, meaning a Senate and a presidency from different parties, have not been filled for over 130 years, going back to 1888. So much like when the Senate exercised its constitutional right, fully consistent with precedent in 2016, not to fill the vacancy when there was divided government, the Senate is today exercising its duty to move forward with processing this nomination, just like the vast majority of Senates in the past have done every time this has happened. And it's important to note that. Any claim that this process is unusual or that it violates the clear precedent of the Senate is simply false. So then, back to the attacks on the members of this committee on the Republican side, and frankly against the president. It says that we're trying to engage in court packing. Now, that's a novel one because it's actually the Senate following standard procedure with regard to a vacancy that is now being accused of being court packing, when my colleagues on the other side are actually proposing court packing. That is, to statutorily and with the signature of a president, change the law so that they can add more members to the court. FDR tried this, and his effort was rejected. That effort should be rejected now, but let's be clear about it. This is not court packing. That, threatening to pass a law and change the court, is court packing. So then what were the arguments that were actually leveled against Judge Barrett? Well, the standard arguments. She is going to overturn all protections for women. She is going to change all of the laws in the country that protect people's health care. And everyone in this country who has a pre-existing condition or has any kind of a worry about getting support needs to worry that she's going to be an activist judge and a justice and go in there and change the law. She's not, and we all know that. This is simply the tired, worn-out argument that is constantly made every time a Republican president nominates a candidate for the bench for the Supreme Court of the United States. And it's never been true, and it will not be true with Judge Barrett. So then the attack is, well, the Republicans don't care about people's health. They won't even try to get COVID relief out. And we're here in a hearing in the Judiciary Committee when we ought to be passing COVID relief legislation. And I've heard several of my colleagues basically say the Republicans are refusing to work on helping to address the COVID crisis. This coming from colleagues who just a month or so ago voted unanimously to filibuster a $500 to $600 billion COVID relief package in the Senate. A COVID relief package, I asked my staff to get me a quick summary of it, that put, as I indicated, somewhere between $500 and $600 billion into more small business loans, unemployment insurance, agriculture and farming assistance, postal service assistance, education assistance, both at the higher education levels and at K through 12, healthcare assistance for pandemic preparation, for strategic stockpiles, for testing, for contact tracing, billions for vaccine and therapeutic and diagnostic development, and the list goes on. We were stopped from proceeding with this legislation by a filibuster of those who now accuse us of not wanting to try to do something. We stand ready if you'll simply let us go to the legislation and pass it. So now, Judge Barrett, let me talk about you. Judge, you have an exemplary academic record and legal credentials, and you are preeminently qualified to serve on our Supreme Court. Following your graduation from law school, you clerked for both the U.S. Court of Appeals for the District of Columbia and the U.S. Supreme Court. At the Supreme Court, you clerked, as everyone knows, for none other than the late Justice Antonin Scalia. Upon receiving your nomination to the Supreme Court, Judge Barrett reflected on her clerkship for Justice Scalia, citing his incalculable influence on her life. She also stated that his judicial philosophy is hers too, and that a judge must apply the law as written. That's what we need in our next Supreme Court justice. Rather than the activist justice that you are being accused of being. Judges are not policymakers, and they must be resolute in setting aside policy views that they may hold. And I know you know that. Should we not take Judge Barrett at her word? As a judge, Supreme Court or otherwise, she must be dedicated to interpreting the law as written with an unparalleled commitment to our Constitution. I've visited with her privately. I've reviewed her record. I have seen nothing that would indicate that she is not telling the truth when she says that is her view of how a judge should conduct herself. I've met with a number of Supreme Court nominees in my service in the Senate, and throughout I've continued to maintain an emphasis on following the law and upholding our Constitution, and that must be a central characteristic of the justices we select for this highly influential part of our government. Judges have a great responsibility to carefully exercise their authority within the limits of the law. Our court system has the responsibility to preserve our constitutional rights, ensure a limited government, and provide speedy and fair justice. Following her clerkships, Judge Barrett spent time in private practice before beginning her tenure as a professor. Her academic scholarship and lengthy analysis of issues facing the federal courts make her uniquely well qualified to serve on our nation's highest court. In particular, Judge Barrett's thoughtful exploration of the precedent and the doctrine of stare decisis demonstrates that she is both intellectual and deliberative in her understanding of the law. Moreover, it's evident that she understands the role of a fair and proper judge. In September 2017, Judge Amy Coney Barrett came before the Senate Judiciary Committee, this committee, after being nominated to the U.S. Circuit Court of Appeals for the Seventh Circuit. During that hearing, she repeatedly expressed her commitment to independent and unbiased decision-making. I was proud to support her confirmation to the Court of Appeals in both the committee and on the Senate floor. Judge Barrett's remarkable resume shows she is a pioneer in the legal field. She will be the fifth woman and the first mother of school-age children to serve on the Supreme Court. In many ways, she's the ideal candidate to fill this current vacancy. Mr. Chairman, I look forward to hearing more from the nominee about her experience and her judicial philosophy. The next few days will prove invaluable as we discuss with Judge Barrett at length the proper role of a judge in our legal system. I look forward to this hearing. Thank you, Mr. Chairman.
Thank you. I believe